shall report the probation officer at such time and place as often as a adult probation department report may require them to do so by certification. Defendant failed to report as instructed on April 6, 2022. This officer spoke with the defendant via jail phone call from Campbell County on May 5, 2022. She was instructed to report to probation upon her release. She failed to do so. Her current whereabouts at that time are unknown. Rule 10, I will meet financial obligations to my probation that may include probationary and EMU fees, court fines, costs, and restitution. I'll make regular payments as instructed, estimated owed $870, probation fees $600, restitution $0, fines $0, cost $270. Defendant has a financial obligation to this court in the amount of $870, $270, and $600 since being placed on probation in November 2020. Defendant has failed to make a single payment towards the court debt, leaving outstanding balance of $870. Rule 11, I understand the special conditions ordered by the court be enforced by the probation department, treatment ineligible, obtain and maintain employment. Defendant has failed to provide any verification of employment and has failed to complete treatment at Middletown Addiction Services, and there was a warrant issued.
All right. What is your plea?
Guilty, Your Honor.
All right. Is that what you want to do today, Ms. Nicole?
Yes.
All right. There will be a guilty plea and a guilty finding. What would you like to say on behalf of your client with regard to sentence?
Your Honor, based on Ms. Nichols' situation now as it relates to Kentucky, we're going to ask the court to consider terminating her probation here and allowing Kentucky to handle the matter. If I may expand further on that.
Yes.
Thank you, Your Honor. On May 31st in Kentucky, Ms. Nichols was found guilty of criminal trespass and tampering. As a result, she has 3 years over her head and a 3-year probationary period in Kentucky. She did not take the probation seriously, unfortunately, and she was picked up in Kentucky. Again, I believe that occurred on July the 13th. The document we gave you dated September 22nd is the order that she continued with intensive outpatient treatment at a place called North Star, and that's the court's order in Kentucky.
North Key.
North Key, I'm sorry, North Key. North Key, and they have a plan for her there on probation, to continue with probation. Given that this court really has 2 months remaining on its initial period, certainly this court can extend that, but given the fact that there are only 2 months left on her original probation here in Hamilton County, and given the fact that Kentucky has a plan for her, we would ask that she just terminate probation here if unsuccessful, and allow her to go to Kentucky and receive treatment there. If the court is not so inclined, then we would ask that she consider transferring this matter to Kentucky and allowing Kentucky to monitor with the additional time over her head that would exist from Ohio.
All right, thank you very much. State?
Your Honor, I would say was referred to court.
All right. Well, I understand her situation. Before I decide, Ms. Nicole, anything you'd like to say?
I would like to start my treatment over there and get things started. Start doing the right thing.
All I heard you say was, I would like to go to treatment over there.
I would like to get my treatment started and get things going and start doing the right thing.
I see. Well, I understand your situation in Kentucky, but all of that happened after your conviction here and your sentence of probation here. Your attorney's right, you have about 2 more months on the community control term that this court ordered, but you've done nothing to comply with it. You have, it's my understanding, you have 3 years hanging over your head in Kentucky, you have 3 years hanging over your head here. So you've done nothing to comply with the court's order. You picked up a new charge, you're on probation in another state, and now you want the court to do what?
It wasn't her idea, Your Honor.
I understand. So You recognize that you need treatment? Is that what you really want?
Yes.
Well, the court is willing to provide you with treatment. Because right now, you could just go to prison, but you're not gonna get the treatment. So what I'm gonna do is I'm going to do a River City evaluation and see if she's eligible for River City, which she probably is, since the judge in Kentucky recommended that she go to North Key. And this court had ordered that she complete services at Middletown. I think it was Middletown Addiction Services. So this is what I'm gonna do. I'm gonna continue this matter for a River City evaluation. We'll come back for sentencing. If you are eligible, it is my intention to order you to complete River City program. Ms. Howard, we get a date. I'm not sure we meet 30 days for River City. October 13th.
Could we do a different day possibly?
The same week or the following?
We could do the 12th or the 14th, either one.
We could do 17th.
All right.
All right, October 17th, is that a Monday?
Yes.
At 9 a.m. Then it's remanded, pending the River City evaluation. Ms. Smalley, who would you like to call next?
There is, I would think about this,
All right.
Yeah, and that's why I think that.
All right, this is the matter of City of Ohio versus Caleb Hampton, case number B 2103819. Ms. Kara Blackney for Mr. Hampton and Ms. Mullen for the State of Ohio. This is set for jury trial today.
It is, Your Honor, and I left the prosecutor and Ms. Howard know it wasn't a jury trial. We have worked out a plea.
All right.
My client and I have been in a lot of contact over the past 4 days. He lives in Fort Myers, Florida. He has attempted every way he can to get here. His home was destroyed. He texted me, or he spoke multiple times over the weekend. He is unable to make it today. I told him that I would come here and explain. He wanted to be via Zoom. I told him if you needed him, that I would more than willing to send that to him so you could see him. But I have had a lot of contact from him with him, and I'm just asking for another day for us to do this week.
All right, well, I'm happy to get another date. I don't have a whole lot of time this month, but I want to get it resolved this month.
We do.
And I'm happy to do it by Zoom, the plea.
You are?
Yes.
Okay, do I need to get him to sign and notarize something and send it back to me previous?
Well, the plea forms have to be signed, and they have to be original, so whatever you need to do to get that facilitated. The plea can be done via Zoom. These are F5s.
Yes. Thank you, Your Honor. I apologize. You've been very patient with us in this case.
All right, so, let's get a date, Ms. Howard, this month for a plea for Mr. Hampton to do his plea by Zoom, and then, we'll go from there.
We could do, October 12th.
Is there any way you can push it out a little further so I can get this mailed to him and back?
Does he have anywhere for it to be mailed?
He says that he's going to attempt to go to his mom's home. I'm not positive. I think we'll be able to find a way. Mail's been pretty slow with everybody lately, though, so I'm afraid it's gonna be slow to Florida. I mean, I can drive down there and pick up packages.
A suggestion may be for you to email the document, you sign the document, and send it back, as opposed to sending it and then sending it.
Yes, yeah. Actually, that was,
They,
The 12th.
could we do later than that? I don't think I can get it to him and back by next week.
Next Wednesday is the 25th.
I can do the 25th.
all right,
Thank you.
October 25th, 9 AM via Zoom.
And just so I know for this courtroom, does he need to sign a jury waiver as well?
Yes.
I didn't want to forget. Thank you, Your Honor.
All right, thank you very much. Yeah, are you ready?
Yeah, can we approach?
Sure.
And I think that, Mr. Jones will need to come down.
Mr. Jones? All right. One second. Ms. Howard, we need Mr. Jones called down. Okay.
Good, so I'll let you go ahead and respond to my stuff.
Judge, there were two different motions that were filed. I can state one was
Who's this
a
on?
Wallace Jones.
Okay, good.
One was a motion to combine the two indictments, a joint review indictments. I spoke to Mr. Jones, he does not have an objection to that.
Is there an objection by the state?
I'm sorry,
Is there an objection by the state?
it's my motion,
Your
Judge.
motion,
Yeah,
okay.
yeah, yeah. And I would, yeah,
Yes, the
Is that the
second,
same victim?
same two victims.
same two victims.
All right.
The second motion filed was a motion to amend the indictment, which after looking at the discovery, I've explained it to him, he's not objecting to the motion to amend the indictment either, as requested by the state.
Okay.
There's also notice for B that they are objecting to. I am going to actually take it back through grand jury and add some charges. And then there's gonna be a motion to combine that indictment with the other two as
So
well.
there's gonna be 3 charges,
There's gonna be three.
3 cases. Okay.
Mhm.
Well, I have to set a trial on these dates now, so. How soon are you gonna be doing that?
I will be calling grand jury to schedule it today.
Okay. All right, and then you wanted me to review the bond.
Yes, please.
I see, and then we continued it so that the state could comply with Marcy's law.
Yes, and I've talked to everybody.
All right, well, okay, so he'll come down. We'll put on the record, the, no objection to the 2 motions. And then I'll give you a trial date. And then, we'll review the bond.
Thank you.
Okay?
Are we gonna need a 404B hearing, or? At that point, there'll be a 404B hearing / motion to combine indictments.
Well, I won't even deal with the 404B until I get to the trial.
Okay,
Okay,
I don't even deal with that until we get to the trial.
okay,
Okay?
sounds good.
thank you.
Thank you. Ms. Howard, is Mr. Jones on his way down?
Yes, ma'am.
And I'll need a date too. Ms. Underwood, Would you ready on number 2 or just 1?
Yes, I'm ready to go for my cases.
Oh. And I know the civil case is here, but it's not until 9:45. All right, this is a matter of State of Ohio versus Wallace Jones, case numbers B 2201341 and B 2202925. Mr. Jones is present in the courtroom with his attorney, Mr. Hersner, and Ms. Colson for the State of Ohio. These matters are set for a clear trial setting today. I have several motions that we'd like to resolve. First of all, there is a motion filed by the state to amend the indictment in case number B 2202925. Is there anything in addition to your written motion, Ms. Colson, you want to say?
No, I will rest on my motion, Judge.
All right, Mr. Hersner?
Judge, I did meet with Mr. Jones on Friday, I went over the motion with him, we will not object to the motion.
All right, the motion to amend the indictment as set forth in the written motion is granted with no objection by the defense. We also have a motion to join the indictments in both case numbers ending in 2925 and 1341. Ms. Olson, is there anything in addition to your written motion that you want to say?
Judge, I will rest on my motion.
All right, Mr. Herzner.
Same judge, I met with him on Friday, and over that motion as well, and there will be no objection from the defense on the joint.
All right, is that accurate, Mr. Wallace, Mr. Jones?
Yes.
All right. So the motion to join the indictments is granted with no objection by the defense. Now, we need to set a trial date and a final pretrial conference on these matters. Start, do the date from, the most recent case, 2925.
Has there been a time waiver signed, Judge?
What?
Has there been a waiver time signed? Because he was arraigned in the latest case, the most recent case back in July. He was arraigned on the newest case back in July.
Okay, just find a date and then we'll deal with that part.
And I have discussed that possibility with the judge. So,
They want to do it. They want it in November.
My November is very full.
Is it, you want to go into January?
Are you able to go into January?
yes, Judge, I had talked to Mr. Jones about the possibility because my jury trial schedule is packed as well in November. And I explained to him the jury trial cutoff. So the only bad time I have in the month of January is the week of January 16th to do a jury trial set before Judge Grant.
All right, the first available date in January.
It'll be January 9th.
I-
January 9th.
I didn't have a trial set that day. It is older than this one and the defendant is locked up.
January 9th is the first date available for trial.
Well, our cutoff is the 5th of December. November is,
I'm talking about January.
ma'am,
I'm talking about January. Is the 9th the earliest?
we can do, the 3rd.
January 3rd.
That's free for me to do.
All right, excellent. January 3rd, 2023, 10 a.m. And then the final pretrial conference.
December 15th.
December 15th?
December 15th will took my schedule.
All right, December 15th at 9 a.m. will be the final pretrial conference. The jury trial will be January 3rd. We do need another status between now and then. And while you're looking for that, let's talk about the motion to reduce the bond. What do you want to say with regard to that?
Judge, I tried to put most of the information in my motion, but I know that Wallace also wanted me to present the court with a certificate that he's completed the MANNA program while he's been in.
All right, now you want to pass it over this way, bring it over this
And Judge, I know that we spoke a little bit about the eye detect test that he had taken, and the court had some questions concerning what that was and why they preferred that instead of the polygraph. So I do have a copy of the report if the court would like to see that as well.
All right, so the certificate of from the MANNA program, it's mentoring against negative actions. This is done in jail.
Correct.
All right.
He took it upon himself to do that program. I believe that Mr. David Fulcher is the one who did the program, and he signed up for it completely.
All right, excellent. All right, now, what is this I'm looking at?
That is the eye detect test. If you remember in my original motion, I had mistakenly put that he had taken a polygraph test. When I received a copy of it, it's actually an eye detect test. I know the court had some questions about why an eye detect test versus a polygraph test. What is exactly is an eye detect test? So this is the report that I received from Mr. Ed Perry, actually is the one who was helping Wallace at the time. So Mr. Perry was kind enough, with Mr. Jones's permission, to give me a copy of that.
All right,
And we'll submit on that as well as the rest of the information.
all right, thank you very much. State?
Judge, I spoke to the mothers of both the victims. The mother of, M, the first to the court, the mother of MW. The mother of MW objects to any reduction in loss.
All right, are these two child victims
Yes, they are.
and they have two different mothers?
They do.
All right, and so one of the victim's mothers objects to reduction of bond?
Yes, and the other one refers to the court.
I see.
She is more focused on the trial, I would say that.
And these victims are
His daughters.
related to, are the defendant's daughters, okay.
But Judge, as far as the state is concerned, the state would also object to any reduction in bond if he is facing life tail charges here. Obviously very concerned with the serious nature of the charges, and I would call the evidence against him strong.
How does this eye polygraph come into play in your cases?
Judge, I believe he had originally completed this because the police department asked him to do a polygraph. And he, at the time, again, it was Mr. Perry who was representing him during the investigation. Mr. Perry had set him up to do the polygraph to comply. He's been compliant, Mr. Jones has been compliant with the police department this entire time. So when they asked him to complete a polygraph, Mr. Perry recommended they do an independent polygraph, and that's where this came in line. Unfortunately, I believe by the time that this polygraph was completed, the police department had already presented the case to the prosecutor's office to present to the grand jury.
All right, but in terms of this information being part of any evidence at trial, it won't be?
We are still determining whether we're going to be able to use the polygraph. I'm going to talk with Mr. Jones and see what our options are concerning that. It may be something that we do attempt to use at trial.
All right. Does Mr. Jones reside with either of the victims?
No, Judge, I believe that he resides with his mother, which was where all of the offenses are alleged to have happened while the children were visiting.
I see. And how old?
Let me check my file for the exact age, but they are quite young, Judge, and these are
Under 10, under 5?
under 10.
I will tell you, Judge, that Mr. Jones has not had any contact with either of the prosecuting witnesses since September of 2021, when that's when the allegations were made. And then, of course, like I said, they did their investigation, he has not had any contact with them. He appeared to all his other prior court appearances with the first cases that came along, he didn't have any violations with EMD. He did post a monetary bond in that case.
Judge, I would note that a large change in circumstances is the other cases were F3s, the original cases were F3s, and now he's facing like tail charges. And I would also note that these two girls are not his only children. And I do not know whether or not he will be, I mean, it will probably depend on the mothers of the other children as to whether or not he will have access to them.
Right now, the bond on case number B2202-925 is $200,000 straight, $200,000 straight. He posted bond on the other matter.
He did, Judge, he was indicated that he would be able to post bond up to $50,000 and 10% on the new charges.
Judge, if I may, I would note that 50,000 at 10% would be extraordinarily low in serious charges.
All right, the court has considered the motion to reduce bond. The court is going to grant the motion to reduce bond. I'm going to set the bond at $150,000 at 10% with EMD and a stay away from the alleged victims and any child under the age of 16.
Thank you, Judge.
You need a status date,
October 25th.
October 25th, can you do that?
Yes, Judge, I think it was you.
October 25th, time waived,
Yes, Judge, we would.
thank you.
Judge, if you need us to put on the record, I did speak with Mr. Jones about waiting time till January trial, and he's okay with waiting time.
All right.
Who's holding, oh, 60?
It's a matter of state of Ohio versus, I think it's Jayana, let's get that wrong, Grigsby. Case number B2200338. This matter is set for jury trial, Ms. Erin Underwood, for Ms. Grigsby, this Molly for the state of Ohio. This matter is set for jury today, Ms. Underwood, what would you like to say?
I did file a motion for a continuance, this is running around there and writing.
Oh, you did? I did. Do you have a copy?
But I can get it touched.
Thank you.
I'll give you another copy. I was wondering why I had so many copies, extra copies of my emails that those happened. So I apologize before that, that's why I had the extra copies, but, Ms. Grigsby, recently, had a baby, and she's just not able to be here, today. So I would anticipate, 6 to 8 weeks recovery time. We'll see if it makes sense now for trial.
Your Honor, from the state, I did speak with officers and I have a few bad days, so hopefully we can avoid that.
All right, so, was this by cesarean?
Yes.
All right. We need a trial date, Ms. Howard, we might can put this on the last date, December 5th. Did you do December 5th? Our last year, trial date of the year.
I can do something.
It looks like that's a good date for all.
All right, excellent, it'll be December 5th. Time waived.
Yes, Your Honor.
Okay, so 2, 2, 5. All right, anything else on that matter?
No, Your Honor.
Well, let me ask this, do you feel that we'll need another date between now and then?
Probably just,
Check in.
Check in, yes.
All right, let's get something in November, because, yeah. Let's just get a status report in November.
About, November 9th.
Wednesdays are typically bad for me.
November 14th.
11 at 9 o'clock. Yes, that's fine.
All right, status will be November 14th. All right, anything else on that case, Ms. Underwood?
No, Your Honor.
Are you ready on Mr. Anderson?
I
Did you say yes?
yes.
All right, all the parties here on the civil matter? I don't see the other council. Okay. Well, I don't see the other council.
You received notice, Your Honor. Mr. Eagle, did you refer to it? You received notice.
Well, I have Mr. Ganson here, Mr. Eagle.
Mr. Green's here, for Mr. Defendant Julia. Mr. Eagle is not here, he's the one that's the defendant, that's the chief.
Yes, that's why I need here, right? I need him here.
Well, I'm the one that's part of the motion.
Yeah, I understand, but
I don't have no indication as to whether he is interested in my motion to withdraw, for me to withdraw.
okay.
But he did receive notice appropriately.
All right. This is a matter of John J. Mulvey versus Charles A. Tate Esquire et al., case number A 1905794. We're here today on a motion to withdraw. On a motion to withdraw as counsel filed by Mr. Ganson for the plaintiff. Mr. Ganson is present, as well as Mr. Green,
And Mr. Mulvey is also here.
and Mr. Mulvey is present. All right. Counsel, what do you want to say? Why do you want to get off of this case after 2.5 years?
Irreconcilable differences, Your Honor. And anything else I would prefer to say in camera because of attorney-client privilege. I do want to point out that Mr. Mulvey was on most of the month of September. That's why there's not a certified mail return receipt, because he was not able to receive that. However, he is here today and has indicated his consent to the withdrawal. But as I said, if there's any other information, that I would prefer to do it in camera because of the attorney-client privilege.
I understand. Mr. Mulvey,
Yes.
if you wouldn't mind stepping up. You're in agreement with this motion to withdraw as counsel? Now, we have a trial date set January 19th,
Yes, we did.
and, I'm sorry, February 6th, or February 6th, January 19th is the final pretrial conference. This matter has been long and protracted, it's 2.5 years old already, and we have a trial date set in February. I intend to try this matter in February. Tell me how this is going to, are you able to get new counsel? Or will you be representing yourself?
I believe I'm gonna be able to get counsel, but as the court is well aware, it's a dense pile of materials. Also, I don't know if the court is aware, we filed a couple of motions. One is a motion to amend the complaint, and another is for sanctions based on new evidence. And I think the court should at least take that into consideration.
Well, I don't have anyone to argue at this point.
I understand, I'm simply putting it before you, Judge, that
Yes,
you're
I
saying that you've got a line in the sand about this court date. I would respectfully say there's some extenuating situations that you might want to take a look at the motions. I believe counsel's been served with a copy of it. As soon as we get the information that's attached to it, we file it right away. But it's kind of I've never experienced this situation. Everybody keeps saying that this case is never saying. I've never seen it.
Well, I will definitely consider the pending motion before me. I have a motion, but I don't have any responses yet, so I'm not even sure if it's right. And then I would need counsel to argue it. So, how soon do you think you can get counsel?
That's a good question. If I do get, what I would perceive possibly is if I'm able to get out of town counsel up in Columbus, if they can argue by Zoom or something like that, that I could probably do easier. If I have to get in town counsel, it might take me a little longer.
Well, I think everyone is pretty clear on my stance with the use of technology. You all have been arguing a lot of things by Zoom, so I'm happy to continue that process. Ms. Finley, how soon can we get this in for a status on Mr. Mulvey's ability to get you counsel?
Would you like a status with you, or
Yeah.
we could do October 26th?
Your Honor, for the court's information, we already have on October the 20th a status report hearing scheduled, just so you know.
Okay. Is that right?
Yes, you'll get a call.
Yeah, I'm not sure that Mr. Mulvey, we'll do the status then. I'm not sure if Mr. Mulvey will be able to get counsel by then or not, but we'll go ahead and keep the status on the 20th as scheduled. And then if you have new counsel, we will,
Do a substitution.
absolutely. All right, your motion to withdraw is granted your proposed entry.
Of course, Your Honor. I'll give Mr. Green a copy of it since he's here. There is the book.
All right,
Thank you, Your Honor.
thank you. Ms. Howard, can you, thank you, can you make a copy of that? You take this in first.
I was gonna do that.
All right, yeah, I'm going to
And
copy.
thank you for squeezing me in today.
All right, thank you.
Mr. Taylor.
Yes.
Thank you, Your Honor.
Thank you.
We have to write our call Rodney Taylor. We have a plea.
I want to make sure who's first, is
Mr. Golden is here, I believe.
before this? All right. This is a matter of State of Ohio versus Rodney Taylor, case number B2200059. Mr. Taylor is present in the courtroom with his attorney, Mr. Gary Goldman, Ms. Pollock for the State of Ohio. This matter is set for jury trial today, but it's my understanding the parties have reached an agreement. Is that accurate, Mr. Goldman?
It is, Your Honor.
All right, is that your understanding today, Mr. Taylor?
Yes, ma'am.
All right. Sir, are you the Rodney Taylor named in this indictment?
Yeah.
Are you the Rodney Taylor named in this case in the indictment?
Yes, ma'am.
Sir, how old are you?
38 tomorrow.
Tomorrow?
Yes, ma'am.
All right. How far did you go in school?
High school.
All right, I'm gonna need you to speak louder.
I graduated high school.
All right, thank you. So you're able to read and write the English language well?
Yes, ma'am.
All right, sir, are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No, ma'am. That's right.
Mr. Taylor, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mr. Goldman's signature here and his bar number. Is this your signature here, sir, where it says defendant?
Yes, ma'am.
This is an acknowledgement by you that you understand you have a constitutional right to have a trial. But when you sign this form, you're indicating, I understand that, but I don't want to have a trial. I'm waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes.
Do you have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to a trial?
No, ma'am.
I also have in my hand a 3-page document entitled Entry, Withdrawing Plea of Not Guilty, and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize Ms. Smollett's signature here. Ms. Smollett, I do recognize your signature. Mr. Goldman's signature here, and up here, sir, where it says signature of defendant. Is that your signature?
Yes, ma'am.
All right, thank you. Ms. Smollett, will you put on the record the party's expectation regarding this plea?
Yes, Your Honor. The plea would be to count 1, the state would dismiss the gun specification, however, there is an agreement to the forfeiture of the firearm that is specified in the indictment. Then we would dismiss count 2, both the charge and the specification for plea to the count 1.
Is that accurate, Mr. Goldman?
Yes, Your Honor.
Is that your understanding too, Mr. Taylor?
Yes, ma'am.
All right. Sir, are you under the influence of any medications, alcohol, or drugs today?
No, ma'am.
Do you now, have you ever been diagnosed with or had to manage any type of mental health difficulties?
No, ma'am.
Are you presently under any type of probation or community control supervision in this or any other state?
No, ma'am.
I'm gonna wait until we finish with that, because this is not. Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all if you enter into this plea of guilty today? Well, other than the dismissal of certain counts, which is count 2, and the gun specification, to count 1, and the specification to count 2. Other than that, has anyone promised you anything?
No, ma'am.
All right. Are you making this plea of your own free will?
Yes, ma'am.
Now, sir, it's my understanding from what the state indicated, you'll be entering a guilty plea to count 1, which is trafficking in marijuana, a felony of the 4th degree, and agreement to the forfeiture of the firearm. Is that what you talked with Mr. Goldman about before this hearing?
Yes, ma'am.
Did you have an opportunity to read and or review this 3-page plea form with your attorney before this hearing?
Yes, ma'am.
Do you understand what it says?
Yes, ma'am.
Do you have any questions about
No, ma'am.
it? Mr. Taylor, do you believe you've had enough time to fully consult with your attorney, Mr. Goldman, about your entire case before this hearing today?
I believe so, ma'am.
Has your lawyer answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had an opportunity to review and or discuss the evidence the state has against you with Mr. Goldman?
Yes, ma'am.
Madam Prosecutor, would you put on the record whether or not the state has provided all discovery evidence, including any Brady material, if any, to your knowledge?
To my knowledge, yes.
All right. Mr. Goldman, you acknowledge receipt of same?
Yes, Your Honor.
Mr. Taylor, are you satisfied with your lawyer, Mr. Goldman?
Yes, ma'am. Very.
Now, sir, do you understand the charge against you in count 1, trafficking in marijuana, a felony of the 4th degree? Do you understand that charge?
Yeah, I do. He broke it down for me. It's just been through it, so.
I need you to speak
I
up.
never been through it, so yeah, he broke it down to me.
All right. Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in count 1 of the indictment, as well as the agreement to the forfeiture of the firearm?
Yes, ma'am.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, ma'am.
Now, count 1, the count to which you're entering guilty plea, it's a felony of the 4th degree. Do you understand that it carries a potential sentence of 6 to 18 months in the Ohio Department of Corrections and up to a maximum fine of $5,000?
Yes, ma'am.
Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years?
Yes, ma'am.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand?
Yes, ma'am.
Are you on post-release control right now? Well, if you are on post-release control, do you understand that being convicted of a new felony offense while on post-release control, that in addition to being punished for the new felony offense, the sentencing court can add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand?
Yes, ma'am.
Do you have any questions so far?
No, ma'am.
Additionally, since this is a felony of the 4th degree, community control is a possibility. That's probation. Do you understand that I could place you on probation or community control for up to 5 years instead of sending you to prison?
Yes, ma'am.
You understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court.
Yes, ma'am.
And if I place you on community control or probation and you violate the conditions of probation or community control, you'll be brought back before me for a more restrictive sanction, which could include a whole host of things. But the most severe penalty could be the imposition of prison time up to the 18 months that I previously discussed with you. Do you understand?
Yes, ma'am.
Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. Do you understand that?
Yes, ma'am.
Mr. Taylor, do you have any questions whatsoever?
No, ma'am.
When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, which was scheduled for today, either to the court or to a jury of 12 persons?
Yes, ma'am.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer, Mr. Goldman?
Yes, ma'am.
Do you understand that you have a right to have witnesses subpoenaed to come to court and testify for you?
Yes, ma'am.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that at trial, you cannot be forced to testify against yourself?
Yes, ma'am.
Do you understand each of these rights as I've explained them?
Yes, ma'am.
Do you have any questions whatsoever about your constitutional rights?
No, ma'am.
Do you have any questions whatsoever about anything we discussed this morning?
I could understand it, but
All right. Do you understand that if you plead guilty, you are giving up or waiving all of these important constitutional rights?
yes, ma'am.
Knowing everything the court has discussed with you today, Mr. Taylor, do you still wish to enter a guilty plea to count 1, trafficking in marijuana, a felony of the 4th degree, as well as agreement to the forfeiture specification in count 2?
Yes, ma'am.
All right. Counsel, is there anything further before I accept the plea?
No, Your Honor.
And your statement of facts?
Yes. On or about January 5th, 2022, Hamilton County, State of Ohio, federally only prepared for shipment, transported, delivered, prepared for distribution, a Schedule I controlled substance, to wit marijuana, when the defendant knew or had reasonable cause to believe that a controlled substance was intended for sale or resale by the defendant or another person, the amount that equaled to or exceeded 200 grams but was less than 1,000 grams. In violation of section 2925.03A2 of the Ohio Revised Code.
All right, Mr. Taylor, did you hear what the prosecutor said you did?
Yes, ma'am.
Is it true?
Yes.
All right. What is your plea to count 1, trafficking in marijuana, a felony of the 4th degree?
Yes.
And you agree to the forfeiture specification in count 2, forfeiture of the firearm? You agree to that? Do you agree that the firearm is to be forfeited?
Oh, yes.
All right. Let the record reflect that Mr. Rodney Taylor was present in court with his attorney, Mr. Goldman, and that Mr. Taylor was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Rodney Taylor understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Rodney Taylor guilty as to count 1, trafficking in marijuana, a felony of the 4th degree, in violation of revised code 2925.03, subsection A2, along with the forfeiture specification in count 2. The first specification, count 1, is dismissed at the state's request. count 2 is dismissed at the state's request. And the first specification to count 2 is dismissed at the state's request. Is there any reason why sentence should not be entered today, Mr. Golden?
No, Your Honor, we're gonna ask you to consider community control. I can tell you that as far as I know, Mr. Taylor has no prior felony convictions, so we'd be willing to waive the PSI if the court is comfortable with that.
All right, I'll allow you to give PSI. Anything else you want to say?
Thank you, Your Honor. First of all, Mr. Taylor's parents are here today, and I know he hesitated when you asked him about the trafficking with regard to the marijuana, where it said intended for sale or resale. And Mr. Taylor's conduct fits the statute, because even giving marijuana away is a violation of the trafficking statute, according to the statute. So he admitted to breaking the statute, but it wasn't his intent to sell marijuana. He uses marijuana and he does give it away. And we had witnesses who testified available today to say that he's given marijuana before the party. Regardless, he is guilty of violating the statute as a trafficking. He's 30, tomorrow he's 38 years old, he's single, he has 5 children, he takes care of 6 children, he takes care of them, he takes them to school, he's working full-time at PW3s. I asked him what he does there, he says he's the heart of the kitchen. He likes his job, no prior felonies that I'm aware of, he does have prior misdemeanor contact, mostly bad driving, he does have some marijuana charges in his record, and receiving stolen property for quite a while there. He was cooperative with the police when he was pulled over. He told the officers, when they asked him that he had a concealed carry permit and he had a weapon, he should have notified the officers immediately when they pulled him over that he had a weapon. I watched the video, he didn't notify them until they asked him to get out of the car, and before he got out of the car, he told them to use a firearm in the vehicle. And he still has a concealed carry violation misdemeanor that he has to deal with downstairs as a result of that. Judge, I would just ask you to consider probation on this. Mr. Taylor tells me he'll be compliant with whatever you ask him to do.
All right, thank you very much. Steve?
Just over the board.
All right, Mr. Taylor, is there anything you'd like to say? And if there is, then speak up, because I can't hear you.
To the mic, no, thank you.
Well, Mr. Taylor, it appears to me, while you have no prior felony record, which is good, that you have an issue with marijuana. Yes, your attorney said you have some misdemeanor convictions regarding marijuana.
Well, there's a little like probation for it back in.
Anything that brings you to court is a problem. Particularly when you get convictions. So, I'm gonna say it again. You obviously have some issues with marijuana.
Yes, ma'am.
Because it brought you here to felony court,
Yes, ma'am.
right? What are you gonna do about it?
We already previously stopped smoking anyway. So.
I can't hear you.
I previously stopped smoking anyway.
Okay, well, I don't really want to talk about what happened in the past. I want to talk about October 3rd, 2022. What are you going to do?
It was October 3rd, I stopped smoking at graduated from Cincinnati Cooks. And I'm working at BW3.
All right.
So I am served safe and everything.
You talk really low, but I know you talk loud.
I'm served safe and food.
You know why I know you can talk louder?
How?
Because you work in the kitchen.
Yeah, we do gotta yell a lot. So.
Yes, I know.
I'm pretty tense.
It's pretty loud in the kitchen.
Yeah.
So if you're a part of the kitchen, you can talk louder than what you're talking about right now.
Yes, ma'am.
All right. All right. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've recently calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. Additionally, I've also considered the seriousness and recidivism factors set forth in revised code 2929.12. Accordingly, I hereby sentence you to a term of 1 year of probation, community control, basic supervision. You will pay court costs. There'll be no fine. I expect that what you're going to do is what you said you're going to do, which is just stop the marijuana.
Yes, ma'am.
I put you on what I consider to be a short-term probation. You successfully completed. Even if you completed a little early, I am willing to terminate you early. I really don't want to see you back here. Now, if I do though, I will tell you that I will sentence you to a term of 18 months in the Ohio Department of Corrections. You understand?
Yes, ma'am.
Do you have any questions?
No, ma'am.
All right. You'll have to report to probation right after court. My staff will send over the paperwork. It will be there before you get there. Anything else, counsel?
No, Your Honor.
Dave?
No.
Mr. Taylor, you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand?
Yes, ma'am.
I wish you well.
Thank you.
All right, I think Miss Underwood, I think Underwood's ready. Underwood, you ready? Ms. Smollett, are you ready for Mr. Anderson?
Yes, Your Honor, just one second, I can file.
Okay. You have some.
We can, okay.
You can do it over here, that's fine. You can do it over here.
Oh, okay.
But the TV's here.
Yeah.
Yes.
Yeah.
Yes, we have some right here. We'll come over here together. Oh. Yes, TV's here.
Ms. Howard.
So, the jury trial is going to start at 11 because we have to get the questionnaires for counsel, and then they're doing what they do upstairs, the jury commission, to get all the jurors ready to come down. I think I have a couple more things to do, Ms. Smollett, in the interim while we wait to get ready for the jury.
Yes.
And so, Ms. Smollett, do you have someone else that, while you're ready to get ready for the jury, or are you're doing it all
I
today?
just have to do it all.
All right. All right. Ms. Desch,
Yes, Kevin.
Mr. Kennedy,
Yes,
is he here?
he is here.
Okay. And then Mr. Teagan, is Mr. Teagan here?
He is, but he's actually been in his own way.
Oh, Mr. Teagan's on his way.
He was here, he checked in, and he was looking for his client, he said he'd be here, he was doing a meeting at 9:60, he'll be right here.
Okay, okay, so before we go on the record, Ms. Dedish, this is set for jury trial for Mr. Kennedy, and a motion to suppress.
That's correct.
Okay, is that what you're ready to do?
No, Your Honor, we are actually going to be withdrawing the motion to suppress at this time. Mr. Kennedy will be changing his plea today.
Do I have the paperwork?
Oh. I said it over. Yeah, I know it didn't touch it. There we go, consent. Sorry, I didn't realize it was over there.
Oh, okay.
I don't know where they're saying it is.
Yeah,
Sure. You just leaving his charge as a single count?
he is.
Okay.
Okay.
All right, this is a matter of State of Ohio versus Gerald Kennedy. Am I pronouncing your name right? All right, Kennedy. Case number B2201-762. Mr. Kennedy is present in the courtroom today with his attorneys, Amy Diddish and Ms. Caitlin Mullet for the State of Ohio. This matter is set for a jury trial today, along with a motion to suppress hearing. Ms. Dedish, how do you want to proceed?
Your Honor, at this time, the defense has to withdraw the motion to suppress. Mr. Kennedy would like to change his plea to guilty at this time.
Mr. Kennedy, is that accurate? All right. Are you the Gerald Kennedy named in this indictment?
Yes.
How old are you, sir?
47.
47? How far did you go in school? So you're able to read and write the English language well? Are you a U.S. citizen?
Yes.
Have you ever served in the military? Mr. Kennedy, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Ms. Dedish's signature here. Is this your signature here, sir, where it says defendant?
Yes, ma'am.
Mr. Kennedy, this is an acknowledgement by you that you understand you have a constitutional right to have a trial, which was set for today. But when you sign this form, you're indicating, I understand that, but I'm waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed this form? Did you sign this form after consulting with your attorney about your constitutional right to a trial?
Yes.
Do you have any questions about this form? Do you have any questions about your constitutional right to a trial? I also have in my hand a 3-page document entitled Entry withdrawing plea of not guilty and entry a plea of guilty. On the 3rd page, there are signatures. I recognize Ms. Mullet's signature here, Ms. Dedish's signature here, and up here where it says signature of defendant. Is that your signature?
No.
All right. Madam Prosecutor, would you please put on the record the party's expectations regarding the plea?
Yes, sure. State is under the impression that he is charged.
All right. Is that your understanding, Ms. Davis?
It is, Your Honor.
Mr. Kennedy, is that your understanding?
Yes.
All right. Sir, are you under the influence of any medications, alcohol, or drugs today?
No.
Do you now, have you ever suffered with or been diagnosed even with any type of mental health difficulties? Are you presently under any type of probation or community control supervision in this or any other state?
Yes.
Can you tell me about that?
Probation.
All right. In Hamilton County?
Yes.
And who you are on probation to?
It's Judge Bender, Your Honor. It's actually for a related charge to this one.
All right, thank you. Sir, has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No.
Has anyone promised you anything at all if you enter into this plea of guilty today? Are you making this plea of your own free will? Now, the state has indicated that it's the expectation of the parties that you will be entering a guilty plea as charged to the single count in the indictment, aggravated possession of drugs, a felony of the 5th degree. Is that what you talked to Ms. Dedish about before this hearing?
Yes.
Did you have an opportunity to review and or read this plea form with your attorney?
Yes.
Do you understand what it says?
Yes.
Do you have any questions about it? Mr. Kennedy, have you had enough time to consult with your attorney about your entire case before this hearing this morning?
Yes.
Has your lawyer answered all of your questions to your satisfaction?
Yes.
Have you had an opportunity to review the evidence that the state has against you with your attorney?
Yes.
Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material, if any, to your knowledge?
To my knowledge, yes.
Ms. Dedish, do you acknowledge receipt of same?
I do, Your Honor.
Mr. Kennedy, are you satisfied with your attorney, Ms. Dedish?
Yes.
Now, sir, do you understand this charge against you, aggravated possession of drugs, a felony of the 5th degree?
Yes.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in this indictment?
Yes.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes.
Now, this being a felony of the 5th degree, do you understand that you're facing between 6 and 12 months as a potential sentence in prison and up to a maximum fine of $2,500?
Yes.
Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years? Do you understand?
Yes.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that?
Yes.
Are you on post-release control or just probation? Well, do you understand that if you are on post-release control and you are convicted of a new felony offense while on post-release control, then in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains on your post-release control time, or whichever is greater. Do you understand?
Yes.
Do you have any questions? Since this is a felony of the 5th degree, community control is a possibility, probation. Do you understand that I could place you on community control or probation for up to 5 years instead of sending you to prison?
Yes.
Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control or probation and you violate the conditions of community control, you will be brought back before me for a more restrictive sanction, which could include a host of things. But the most severe penalty could be the imposition of prison time up to 12 months. Do you understand?
Yes.
Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service. Do you understand that? Any questions? When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify on your behalf? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at trial, you cannot be forced to testify against yourself? Do you understand each of these rights as I've explained them? Do you have any questions whatsoever about your constitutional rights?
No.
Do you have any questions whatsoever about anything we've discussed?
No.
Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights? Knowing everything the court has discussed with you today, Mr. Kennedy, do you still wish to enter a guilty plea as charged to the single count in the indictment, aggravated possession of drugs, a felony of the 5th degree? Counsel, is there anything further before I accept the plea?
No, Your Honor.
May I hear a statement of facts?
On or about April 11, 2022, in Hamilton County, State of Ohio, defendant knowingly obtained or possessed a Schedule II controlled substance, methamphetamine, in an amount less than law, violation of 2925.11A.
All right, Mr. Kennedy, do you hear what the prosecutor said you did?
Yes.
Is it true?
Yes.
What is your plea to count 1, aggravated possession of drugs, a felony of the 5th degree?
Yes.
Let the record reflect that Gerald Kennedy was present in court with his attorney, Ms. Amy Divish, and that Mr. Kennedy was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Gerald Kennedy understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Gerald Kennedy guilty as to count 1, aggravated possession of drugs, a felony of the 5th degree, in violation of revised code 2925.11 subsection A. Is there any reason why sentence should not be entered today, counsel?
No, Your Honor.
Who would like to say on behalf of Mr. Kennedy?
Yes, Your Honor. Mr. Kennedy is 47 years old. This is, it looks like to be his first charge since about 2016. So he's been staying out.
Since when?
2016. So he's been staying out of trouble for a while. He lives in Cheviot. He's not currently working because he gets Social Security disability. That is due to the fact that he has some rods and pins in one of his legs. He also suffers from sarcoidosis, which is a heart condition. He actually has a pacemaker, and then he obviously eats all the time. He has a lot of medical appointments due to that condition. This was originally related to a misdemeanor OVI charge that we alluded to somewhat earlier. He's already on probation for that charge. He has already entered a plea. His probation officer is aware that this charge, since they came down at the same time. Your Honor, as far as the actual substance in this case, this was a situation where Mr. Kennedy thought what he had was a few ecstasy pills. It was into the lab and came back as methamphetamine. Obviously, that was a concerning result to him, and has shown him that, you know, he doesn't really know what you're ending up with. And I think it showed him that he shouldn't try to use ecstasy anymore. His license is suspended due to the OVI charge. His fiance has been taking him to all of his probation appointments for the misdemeanor, as well as all of his medical appointments. Obviously, he also has a lot of fines, because they're mandatory fines for an OVI case, as well as probation costs, and he is on a limited income. And he did serve 4 days total on this charge. We are asked, and he's already on probation for the same incident. Obviously, with the OVI charge, they will assess him for any substance abuse treatment that is needed, and all those kinds of things. He's already on supervision. So we are asking the court to consider possibly not placing him on a period of probation, or if he is placed on period of probation or discharge, to make it non-reporting probation, so that he won't have to double up with the probation appointments. It is my understanding, just from past experience, that if you're on probation for misdemeanor and a felony, they will give you 2 separate probation officers. And we would like to avoid that for Mr. Kennedy if possible, just due to his medical issues and the fact that he doesn't have a driver's license. That would be pretty burdensome for him to have 2 separate probations.
All right, thank you. State,
I'll defer to the board.
so he's on probation in misdemeanor court,
That's correct.
and how long is that probation?
It is a 9-month period of probation.
I'm sorry,
9 months,
9 months?
yes.
When was he placed on probation?
I believe it was August 15th.
Oh, last month?
Yes.
Well, before it's already October. Okay. All right. Anything you can say?
No.
All right, what would you like to say, Mr. Kennedy? Okay, wait. I can't hear you. Okay, yes, speak loud.
I just learned a valuable lesson about these drugs, these drugs that I know they had meth in the pills.
You didn't know there was meth in the pills?
No, they actually did, I don't know anything that.
Oh, I see.
Yes. Too old for this.
All right. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines. Accomplish the purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I have reasonably calculated this sentence to achieve the 2 overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors set forth in the revised code 2929.12. Accordingly, Mr. Kennedy, I hereby sentence you to a term of 6 months community control, basic supervision, you will pay court costs, there will be no fine. If you violate, I will sentence you to 12 months in the Ohio Department of Corrections. Do you understand? All right, so now I'm not going to put reporting or non-reporting, I'm just gonna put basic supervision. But if the probation officer confirms that he'd have to report to 2 different people, then I will make my non-reporting. Other than that, he just needs to report to probation. Okay? All right. You have a right to appeal your conviction and sentence. You must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand? All right, and for the record, Ms. Dedish, are you withdrawing your motion to suppress?
Yes, ma'am.
All right, I wish you well. You need to go to probation right away. The paperwork will be ahead of you and go over there before you. You understand? All right, thank you.
Thank you.
You go to the jury.
It's
Council, you've been very patient.
Good morning, Your Honor.
Good morning. One moment. Mr. Abdullah?
Yes.
Okay. Oh, prosecutor.
I'm grab my client, she's in the hall.
Okay, great. It's gonna be size and that.
What's that?
Yeah, you are one of the people last week.
Did you get a copy of the violation of size more than small?
No.
Okay, we can get that to you.
That was just crazy. That's very possible too.
Yeah, I just, no, I think we went to the way.
You gave me the one, but I didn't see the other, but there's a big chance it's lost in my head.
Yeah.
All right, are we ready?
Yes, sir.
This is the matter of State of Ohio versus Angela Sizemore, case number B 2102416. Ms. Sizemore is present in the courtroom with her attorney, Mr. Mohammed Hamadullah, and Ms. Caitlin Malik for the State of Ohio. This matter is here for a probation violation. Have you received a copy, Mr. Hamadullah?
Yes, sir.
All right, and you as well, Ms. Mullet?
Yes.
All right. Would you like to have a probable cause hearing?
No, Your Honor, I was speaking with my client, she does admit that she did fail two drug tests, and passed previous ones, but did fail the last two drug tests, so we are meeting the violation.
All right, so you're waiving the probable cause and entering a guilty plea?
Yes.
All right, is that what you want to do today, Ms. Sizemore?
Yes.
All right, may I hear statement of facts?
Yes, Your Honor. In this matter, we have several cases under B 2102416, count 1 through 5. Since being placed on community control, the defendant's adjustment has been insufficient to the standards of probation. Defendant failed to report as directed to the probation department, failed to be compliant with stated treatment, failed to abstain from illegal drugs, failed to give probation accurate information, and failed to conduct himself properly by receiving new charges. Your Honor, the defendant initially reported in March of 22, the discussed treatment options, and the defendant was directed to report back on April 7th. She failed to appear back on April 7th. And then she did report on April 12th. However, during the visit, she was unable to get into treatment due to not having insurance, is what her statement was. She did report on May 5th. And she was unable to provide a sample as directed, was reported back on 6/2/22. Defendant failed to report on 6/2/22. They were told on 6/7 that they were trying to report back for treatment. 7/1, probation was contacted by Child Services in Butler County concerning the defendant. And she was arrested and charged on May 13, 2022 with 2 felony charges. And those charges were ignored and laid on 6/29/22. But they were having difficult time getting hold of the defendant. She failed to return on July 7th. Sorry, I'm trying to read it a little bit further here. Looks like she'd only been in treatment as of July 28, 2022, since one time since the intake the previous month of June. July 22nd, detectives in Butler County contacted probation stating he was attempting to get in contact with the defendant regarding his child. Defendant did not appear to live in that setting. On July 29th, defendant contacted probation saying she was getting back to treatment. Probation directed the defendant to report back to the office on 7/29. And then 8/5, the defendant was actually arrested in Butler County. And
What was that?
That was on August 5th, 2022. The defendant was arrested in Butler County with a new charge of interference in custody with her child. And the defendant was released from custody on August 8th, 2022. On August 16th, Sunrise Treatment contacted probation saying the defendant was unsuccessfully discharged. At that point, on 8/29, probation was contacted by the defendant's caseworker through Child Services. Was told the defendant had been non-compliant and was positive in a recent urine screen for fentanyl, methamphetamines, cocaine, and heroin found on August 29, 2022. Probation attempted to contact the defendant for bail on September 6, 2022. The defendant reported on her directed reporting day of the month. During the visit, the defendant was questioned about her recent urine screens. She stated she had no idea how she would be positive, she'd be clean today. Defendant was questioned about her treatment. Defendant stated that she was asked not to go back to treatment. Defendant was sent for a urine screen that was positive with fentanyl and was directed to report back on 9/20, 2022. 9/6, probation was contacted the defendant's caseworker to confirm that she was to solely attend treatment referred to by Butler County, and probation was told that she was encouraged to attend both treatments. On 9/20, defendant failed to report as directed. On 9/22, defendant reported as directed during the office visit. Defendant was cited for a probation violation here in front of her due to the multiple issues that have been mentioned previously.
All right, thank you very much. You hear what the prosecutor said for the violations? All right, is it true?
Yes.
All right. What's your plea to the violations?
Guilty.
All right. There'll be a guilty finding as a probation violation for me. All right, what would you like to say on behalf of Ms. Sizemore, Mr. Honolulu, because she is supposed to be in ILC right now. And this is a complete violation of the terms of intervention in group treatment. So at this point, it is my inclination to revoke her treatment in lieu. But before I do that, I'm gonna listen to you.
Yes, Your Honor, just speaking with my client, obviously, she's got a strong, serious addiction issue that has been a bumpy road, to say the least. However, just going through, some of the statement facts regarding her contact, I did see that she had felony charges back in May that were dismissed or not indicted on. Understanding that the charges she just arrested on in August. It was regarding her child or children's services, and my understanding those charges were dismissed as well.
Yes.
So those charges, so as far as picking up new charges, I believe there's nothing pending, especially in felony charges, Your Honor. I think this is a matter of Ms. Sizemore getting treatment and understanding the importance of treatment. I know through Children's Services in Butler County, they did remove her child. She is set for a SAMI assessment for substance abuse and mental health. I believe we have an assessment on the 5th.
Yes.
And so she is set for that assessment. I think what Children's Services wants is want her to get clean and healthy and to be able to abstain from use of the drugs. So you can decide which medication she can, submit past her drug screen today. She is not going to use it.
All right, thank you very much. Sir, your name?
Nick Grant from the state.
All right, thank you very much. What would you like to say on behalf of the state?
Your Honor, the state will defer to Your Honor.
All right. Well, the treatment in lieu is revoked. And at this time, I am, Ms. Sizemore pled guilty to counts 1, 2, 3, 4, and 5 on February 28th. The court held that in advance and made no finding. I'm accepting those guilty pleas at this time and finding Angela Sizemore guilty as to counts 1, possession of heroin, felony of the 3rd degree. Count 2, possession of fentanyl-related compound, a felony of the 3rd degree. Count 3, possession of cocaine, a felony of the 4th degree. Count 4, aggravated possession of drugs, a felony of the 5th degree. And count 5, possession of drugs, a felony of the 5th degree. Ms. Sizemore, is there anything you want to say before I pass sentence?
No, I just had a bumpy road and I'm clean now and I want to go do my assessments so I can get my child back.
All right, well, what I'm going to do is I'm going to order a pre-sentence investigation report. I'm going to order a River City evaluation. And you're going to get a sentencing date.
How about, October 17th?
We're going to get a PSI.
November 7th.
November 7th? Can you do that, Mr. Honolulu?
Here in Butler County that day, is it possible I'm here in the courthouse on November 14th, that following Monday?
Let's see.
Is fine.
All right, November 14th, 9 a.m. Defendant is remanded at this time till sentencing for the PSI and the River City evaluation. I didn't do, is Mr. Where is Mr. Oh, Ms. Bennett, do you represent, Saunders?
I do.
Okay, great. Are we ready?
Yes, I think he should be on his way down.
Okay, all right, great. That's the last one, I'm ready for the trial.
Okay.
Mr. Tupin, this one, this is the trial. Mr. Tupin, and I just need to get this, Veterans case over with, and then Mr. Tupin should be here. What do you want to do on Mr. Saunders instead?
He's going to adjourn, please. He's going to adjourn, please.
Okay. You all working on the paperwork?
Yes, Your Honor, I believe Caleb's gonna be right back, come more delayed.
All right, Mr. Tupin,
Yes, Your Honor.
you ready?
I believe so.
What do you want to do on your case?
Okay. I believe we need to see this more than,
Mr. Tupin, what do you want to do?
Your Honor, I believe we'll be maintaining a not guilty. I believe Ms. Melton said there's no prosecuting witness present today, but
I
I
see.
think the prosecutor in here now wants to wait for her, so she checked.
All right.
That's fine.
All right.
Thank you.
And Ms. Underwood, you have the jury questionnaires.
Yes, Your Honor.
Yes. Yeah, that's a hard conversation, it's not. I bet. Yeah.
Everything.
You guys know who's gonna be the prosecutor? Huh? Who's gonna be the prosecutor? No. No, because it's not agreed.
See, if you have any questions.
Okay, all right, perfect. All right, good.
Let me follow up just to see if she can get through the list.
What?
Oh, no. I thought you were here.
Mr. Grant, he signed it, but,
Okay.
Sure, yeah. Yeah, it's good, yeah. So you can just. Well, I understand it for the guy too, that was never the facts, it's not being us that.
Michelle, basically, that. We're outside, it's called. Each file,
the place you want?
No, I think I brought it. We had it, here it is. Here it is, I found it. Thank you.
Ms. Dervish, are you gonna ask for PSI? You waiting?
Yes.
All right.
This is Mr. Saunders.
It's your call.
This is a matter of state of Ohio versus Zachary Saunders. Case number B 210-5903B. Mr. Saunders is present in the courtroom with his attorney, Ms. Amy Dedish, and Ms. Caitlin Mullen for the state of Ohio. This matter is here on a pre-conviction habeas return We scheduled it as a status report. And it's my understanding the parties have reached an agreement. Is that accurate, Ms. Devish?
It is, Your Honor.
All right, is that your understanding today, Mr. Saunders? All right. Ms. Devish, I'm just gonna give this plea form back to you, just have Mr. Saunders put his name right there in that blank form, that blank line. Are you the Zachary Saunders named in this indictment? Are you the Zachary Saunders named in this indictment? What is, how old are you?
28.
How far did you go in school?
I don't know the.
So you're able to read and write English language well?
Yes, Your Honor.
All right. Are you a U.S. citizen?
Yes.
Have you ever served in the military?
No,
Mr. Saunders, I have in my hand a single-page document entitled Waiver of Trial by Jury, and the bottom there are signatures. I recognize Ms. Devish's signature here, but right here, is this your signature, sir?
yes, it is, Your Honor.
This is an acknowledgement by you that you understand you have a constitutional right to have a trial. But when you sign this form, you're indicating to the court, I understand I have that right, but I'm waiving it, I'm giving up my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes, it is.
Did you sign this form after consulting with your attorney about your constitutional right to a trial?
Yes, it is.
Do you have any questions about this form?
No, Your Honor.
Do you have any questions about your constitutional right to a trial?
No.
I also have in my hand a 3-page form entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize this, no, that's not Ms. Moxley.
No, it's, Mr. Grant, he was another assistant prosecutor, he was filling in while I covered the court.
Okay, is he gonna fill in while you prepare for jury?
Your Honor, I don't know that, I think we got one more case, so I'll just handle it since he isn't.
Okay, all right, so this is under the prosecutor's signature. I recognize Ms. Devish's signature. Is this your signature up here, sir, where it says signature of defendant?
Yes, it is, Your Honor.
All right, thank you. Madam Prosecutor, would you please put on the record the party's expectation regarding the plea?
Yes, Your Honor, my understanding is that the defendant will be pleading to count 1 and count 3, and the state will dismiss count 2 and 4 as it applies to defendant B, Mr. Saunders, in acceptance of the plea for the other 2 counts.
Is that accurate, Ms. Devish?
It is, Your Honor.
Is that your understanding today, Mr. Saunders?
Yes, it is, Your Honor.
Sir, are you under the influence of any medications, alcohol, or drugs today?
No.
Do you now, have you ever suffered with or even had to manage any type of mental health difficulties? Are you presently under any type of probation or community control in this state or any other state?
No, I'm not.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, Your Honor.
Has anyone promised you anything at all other than the dismissal of count 2 and 4 if you enter into this plea of guilty today?
No, Your
Are you making this plea of your own free will?
Honor. Yes, I am.
Now, the state has indicated that you will be pleading guilty to counts 1 and 3, which are felonies of the 5th degree. Is that what you talked with your attorney about before this hearing?
Yes, it is, Your Honor.
Did you have an opportunity, Mr. Saunders, to read this 3-page plea form and or go over it with your lawyer?
Yes, Your Honor.
Do you understand what it says?
Yes.
Do you have any questions about it?
No, Your Honor.
Do you believe you've had enough time to fully consult with your attorney before this plea hearing today?
Yes, it is.
Has your lawyer answered all of your questions to your satisfaction?
Yes, it is.
Have you had an opportunity to review and or discuss the discovery evidence that the state has against you and discuss it with your lawyer? Madam Prosecutor, would you please put on the record the party's expectation regarding the plea? No, I'm sorry. Madam Prosecutor, will you please put on the record whether the state has provided all discovery evidence, including any Brady material, if any, to your knowledge?
To the best of my knowledge, yes.
Ms. Devish, do you acknowledge receipt of same?
I do, Your Honor.
All right. Mr. Saunders, are you satisfied with your attorney?
Yes.
Now, sir, do you understand the charges against you? Count 1, aggravated possession of drugs, a felony of the 5th degree.
Yes, I do.
And count 3, possession of a fentanyl-related compound, a felony of the 5th degree.
Yes, I do.
Do you understand if you plead guilty to these offenses, you are making a complete admission that you committed the allegations contained in these 2 counts of the indictment?
Yes, Your Honor.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, Your Honor.
Now, these being felonies of the 5th degree, do you understand that you are facing between 6 and 12 months in the Ohio Department of Corrections and up to a maximum fine of $2,500 on each count?
Yes, I do, Your Honor.
Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years?
Yes, I do, Your Honor.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand?
Yes, Your Honor.
Are you on post-release control right now?
No, I'm not.
Do you understand that if you are on post-release control and you're convicted of a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand that?
Yes, I do.
Since this is a felony, and both of these are felonies of the 5th degree, community control is a possibility. Do you understand that I could place you on community control or probation for up to 5 years instead of sending you to prison?
Yes, I do, Your Honor.
Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court?
Yes, I do.
And if I place you on community control or probation and you violate the conditions of probation, you'll be brought back before me for a more restrictive sanction, which could include the imposition of, among other things, a whole host of other things, the imposition of prison time up to 12 months that I previously discussed with you. Do you understand?
Yes, I do, Your Honor.
Do you have any questions so far?
No, ma'am.
Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. You understand?
Yes, Your Honor.
Mr. Saunders, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes, I do, Your Honor.
Do you understand you have a right to confront witnesses here in open court and have them cross-examined by your lawyer, Ms. Devish?
Yes, I do, Your Honor.
Do you understand that you have a right to have witnesses subpoenaed to come to court and testify for you?
Yes.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond reasonable doubt?
Yes, I do, Your Honor.
And finally, do you understand that at trial, you cannot be forced to testify against yourself?
Yes.
Do you understand each of these rights as I explained them?
Yes, I do, Your Honor.
Do you have any questions whatsoever about your constitutional rights?
No, ma'am.
Do you have any questions whatsoever about anything we discussed today?
No, ma'am.
Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights?
Yes, I do, Your Honor.
Mr. Saunders, knowing everything the court has discussed with you, do you still wish to enter a guilty plea to count 1, aggravated possession of drugs, and count 3, possession of a fentanyl-related compound?
Yes, I do, Your Honor.
Counsel, is there anything further before I accept the plea?
No, Your Honor.
May I hear a statement of facts?
Yes, on count 1, on or about November 18, 2022, in Hamilton County, State of Ohio, that knowingly obtained, possessed, or used a Schedule 1 controlled substance. It's flunitrazepam, FLUNITRAZAPAM, for court reporter, Your Honor, and then on count 3, saying date, time, and location, that knowingly obtained or possessed a Schedule 2 controlled substance, fentanyl, in the amount less than 1 gram. Violation of 2925.11A of the Ohio Revised Code.
All right. Mr. Saunders, did you hear what the prosecutor said you did? Is it true?
Yes, Your Honor.
What is your plea to count 1, aggravated possession of drugs, a felony of the 5th degree?
Guilty.
What is your plea to count 3, possession of a fentanyl-related compound, a felony of the 5th degree? Let the record reflect that Mr. Zachary Saunders was present in court with his attorney, Ms. Amy Dedish, and that Mr. Saunders was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Saunders understands the nature of the charges, the effect of the pleas, as well as the maximum penalties which can be imposed. Finding them to be voluntary, the court accepts the guilty pleas and finds Zachary Saunders guilty as to count 1, aggravated possession of drugs, a felony of the 5th degree, and guilty as to count 3, possession of a fentanyl-related compound, a felony of the 5th degree. Counts 2 and 4 will be dismissed at the state's request. Is there any reason why sentence should not be entered today, Ms. Dedish?
No, Your Honor.
Are you waiving the PSI?
We will.
All right, who would you like to say on behalf of Mr. Saunders?
Yes, Your Honor, Mr. Saunders is 20 years old. Obviously, we are here on habeas return. The last that anyone in this room had heard of Mr. Saunders before he habeas on this case was, I think, back in May, when he was in the Phoenix Center doing inpatient treatment there. He did leave the Phoenix Center and complete 28-day inpatient treatment at the Burr in Westchester. From there, he went to a sober living house in Dayton, Ohio, called Fresh Start. The Laverse Treatment Center set him up with that. He had a sponsor there. He was doing NA 5 times a week. He was getting drug counseling as well as mental health counseling. He's been diagnosed with anxiety and depression. He was doing that every day. They were also setting him up with a Vivitrol shot. He was doing very well there. He really liked it. And while he was there, they informed him that he had a warrant out of Claremont County for a probation violation. So he turned himself in on that warrant and did about 80 days over in Claremont County. He was brought from Claremont County directly to our jail here. So, and that's why he missed court here, because he was incarcerated in Claremont County. The probation violation over there was for a drug-related felony as well. They terminated his probation, so he's no longer on probation over there. At this point, he's been clean for about 6 months. His hope is that he will be able to go back to Fresh Start in Dayton. As I said, he is all set up with treatment over there and is doing well, and I think that their plan is to help him transition back into the community eventually as well, with some job services, housing services, things like that. So we're just asking the court possibly for a period of probation. They could hopefully allow him to follow that treatment there.
All right, thank you very much. State? All right. Mr. Saunders, what would you like to say?
I mean, she pretty much covered the rest of it. Before I go to Fresh Start, though, they want me to go back to Lemire for a 28-day program to do the Vivitrol shot and stuff. But my mother already has like the bed available and open. Like, I have great social support out there. Like I've been doing.
You have to pay for that?
No.
It's,
I have care for Medicaid, so.
Okay.
And I mean, like she said, I've been sober 6 months now. I was just currently locked up in Claremont, so my head's clear. You know what I mean? Like I'm not. But with that, I mean, I hope for the chance of probation.
All right. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing a necessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've reasonably calculated this sentence to achieve the 2 overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be commensurate with and consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors set forth in revised code 2929.12. Accordingly, Mr. Saunders, I hereby sentence you to a term of 1 year community control, basic supervision. I will remit costs and fines because you have been incarcerated for so long. I will tell you that if you violate the terms of community control, I will sentence you to a term of 12 months in the Ohio Department of Corrections. Do you understand?
Yes, I do.
All right, you have any questions?
That's it, thank you.
All right, anything further, counsel?
No, Your Honor.
State?
No, Your Honor.
You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand?
Yes, I do, Your Honor.
I wish you well. Only says- Mr. Tippett,
Yes, sir.
you are the caboose before I start the trial. This is a matter of state of Ohio. Versus, is it Gerard? Gerard Whitehead, case number B 2201965. Mr. Whitehead is present in the courtroom with his attorney, Mr. Craig Tippett, and Ms. Caitlin Mullet for the state of Ohio. This matter is set for jury trial today. Are parties ready for trial?
Judge, we are prepared to proceed and may complete not guilty.
All right. State.
Your Honor, state's unable to go forward. The prosecuting witness that is necessary for this case is not present here today. My understanding and the notes that indicate that the prior prosecutor actually served the prosecuting witness in person at the last setting. I would ask for a continuance for the record, Your Honor.
All right.
Your Honor, we would object and ask for dismissal. I know we've been waiting on potential video or picture that never came to, and I know the previous prosecutor said they had trouble getting any response from the prosecuting witness as to that issue.
All right. Prosecuting witness has been properly served and is not here for trial. The matter is set for 10 o'clock for trial. It is now 11:41 a.m. The matter is dismissed for warrant prosecution. You are free to go.
Thank you, Your Honor. Thank you.
Your Honor, maybe you speak to you about logistic things for the jury, just in.
Yeah. We can go in my office.
Perfect.
Thanks.
14 cases. Hey, we start. So if the jurors include, if they need to have teams for the other 10. You're technical. Yes. Okay, and then probably, I can do that back. Good for your hour. I'll be able to thank you.
1 o'clock. All right, this is a matter of State of Ohio versus Latrell Amison. Case number B22015999. This matter is set for jury trial today. Mr. Amison is present in the courtroom with his attorney, Mr. Underwood, Ms. Caitlin Mullen for the State of Ohio. So, it's my understanding that the parties want to proceed to trial. Is that accurate, Ms. Underwood?
Yes, Your Honor.
All right. Is that accurate, sir?
Yes, ma'am.
All right. And before we, the jury's already I intend to break for lunch till 1, because the jury has literally been sitting upstairs since 9 this morning. So I want them to be attentive and engaged in the process, and so I'm going to let them go to lunch and then come back, and we're gonna get started at 1 o'clock on the nose. Now, I understand there's been an offer from the state, and I'd like to have that place of record, at this time.
Yes, Your Honor. The state offered a plea to count 1 with the defendant's, possession, or for forfeiture of the firearm, as far as the defendant's, right to the firearm. We asked for a forfeiture of that firearm. He says he will forfeit any right he has to that firearm, and we would dismiss count 1 for that and then defer to the court for sentencing.
You dismiss count 1 and then you plead the cease together?
Yes.
All right. Ms. Underwood, anything you want to say?
I did speak to Cottrell about that offer. We reviewed the evidence, we reviewed the law, and at this time, he declines that offer.
Okay. And okay. Is that accurate, Mr. Anderson?
Yes, ma'am.
All right, so we will, I want it to be on the record that you were made the offer, and the record is now clear that you rejected that offer. So we will proceed to trial beginning at 1 o'clock. Everyone can come back a couple minutes before, and we'll have the jury all the way down here, okay?
Thank you
All
very
right,
much.
thank you very much. You can leave it here, Ms. Underwood, or leave it out. The room will be locked and secure. Just so.
No problem, busy checking some
Oh, okay.
okay. Sheets and everything.
Ms. Howard, if you wouldn't mind, please, pausing the live stream, please. Pausing.
Thank you for the offer. One.